You may stand up, accused 1 and 2. Accused 1, in respect of counts 1, 2, 3, 4 and 5, you are found guilty as charged. Accused 2, Mr. Snyman, in respect of counts 4 and 6, you are found not guilty and discharged. With regards to accused 1, on evaluation, it was evident that the only aspect to be decided on was whether he fired a real or toy gun. The said firearm, toy or real, was indeed handed to him by Mr. Mavundla, and during his evidence he testified that Mr. Mavundla should have been charged. This begs the question, charged for what? Handing you the toy firearm, or then alternatively the SPA 249-14? The answer is nonsensical as to why Larry Mavundla should have been charged. In effect, the further particulars indicate a warning statement was obtained from Larry Mavundla as per A121. And just to elaborate on one aspect, sorry, I need to revert to the defense case on behalf of accused 2. Apologies, number 1. It also comes to mind that Advocate Matthews had put to the witness that, being Colonel Mgwadleka, he had received instructions from the said protecting officer, being Larry Mavundla, that the breech block of CN SPA 249-14 has not been changed or altered in any manner. Now that statement remains a mere statement. The person on whose instructions Advocate Matthews placed this statement to the witness was not called to substantiate. Therefore, it is a mere statement done in cross-examination. It also further then begs the question, if he had left the firearm in Gauteng as stated, he cannot make such a version or instruction to Advocate Matthews, because in his version or their version, he had not possession of the firearm during that time. Now, to return to accused number 1, I've dealt with as to why he states Mr. Mavundla should be charged. He also relies on the video footage of clip 3. I mention this as a mere reason that it was part of his evidence, and he identifies Mavundla, who was not called to testify, and identifies Chauke. Now, when read the statement regarding identifying Chauke, read with Chauke's evidence or statement that he was not on the stage or present on the stage, leaves a question mark. During cross-examination, which I've already placed on record the aspects, the evaluation is as follows. Mr. Malema had evaded many questions that had warranted a reply. It became evident that the replies were entertaining, but however, the pertinent questions asked remained unanswered. He further relied on clip 3, and he had then counted 15 shots fired, and thereafter stated he cannot count, he had graduated in woodwork. Further, as to how the cartridge or the SPA 249-14 is linked to him, his reply was it must have been the Holy Spirit, and these type of answers did not do accused 1 any favors. In essence, when one is questioned in the witness stand and a mere question is asked from you which elicits a response, one would expect that the question will be answered. Therefore, the court needs to deal or to establish whether the version presented by the defense is reasonably possibly true. Based on the reasons placed on record, including the evidence that it had dealt with over the last 2 days, whether such inference can be made, and the court finds as follows. Indeed, the inference sought is supported by all the facts contained as per the evidence presented in court, and therefore the following findings are made. You may stand up, accused 1 and 2. Accused 1, in respect of counts 1, 2, 3, 4 and 5, you are found guilty as charged. Accused 2, Mr. Snyman, in respect of counts 4 and 6, you are found not guilty and discharged. You may be seated. Okay. At this point, the court will then just... Is there something you wanted to place on record?
Yes, Your Worship. I just want to say accused number 1 is no previous conviction.
Same is noted.
At this stage, because of the shortage of time, my instructions are to apply for postponement and for the continued release of the accused on warning. He's been on warning since the outset and has always appeared at court.
The court has no intention of changing the status of your client, Advocate Otis, so I am completely in agreement with that, and further that it's not possible to deal with the rest of the proceedings today.
In that regard, Your Worship, it's our intention to obtain a pre-sentence report, and for that purpose we need to arrange a date with Your Worship.
Okay, so at this point, just so that you may have a word with your client regarding his schedule. Of course, Advocate Matthews, you are now excused from record.
I'm going to catch my train.
Yes, it will take you about a decade or so.
Could I just say something to you?
Yes.
I just want to thank you because you have been very patient with it. And you have, on many occasions, allowed the case to continue without us being fit.
Thank you, Advocate Matthews. It's much appreciated. Mr. Snyman, it will be your choice whether you stand down and leave Mr. Malema, or if you want to remain seated next to him. That will... Sorry?
I'll remain.
All right, I assumed as such. Just to take instructions regarding the time frame, suitable date, whatever I have on a specific day. Mr. Malema, the matter is then postponed.
I'm fine.
Procedure by time, and then if you find I'm fine, the matter is postponed to the 23rd of January for the pre-sentence reports. Now in this regard, I want to place on record, I am not sure as to whether the defense, being Advocate Otis and yourself, will be leading evidence or calling witnesses in that regard, and then the state to address. So depending on how much time is utilized in that process, I cannot say sentence will be pronounced on the same day. It depends on what you will be presenting before court on that day. Therefore, bail extended, warned 9 o'clock to proceed, 23 January 2026.
May the court please.
Thank you. The court is adjourned, then I will continue with my normal role for the day.